Hello everyone, welcome to IAS Baba's 60 days rapid revision series for Prelims 2022. This is day 26 and we take up the polity topics again. Friends, before going to the topics, I want to say that it is like from the class 41 to 60. So we are taking up some of the guessworks for the 2021 prelims. That is how to tackle the question with minimum usage of knowledge. So by analyzing the keywords, by analyzing the statements, by analyzing the examiner's mindset when he was setting the question. So all those things we will use. So we use the knowledge as less as possible. So these are the ones which are going to give you the good marks in prelims. So make sure that even you will come with your guessing strategies and we will see how many questions we can take the guesses. Then come to the topic. So discretionary power of governors. So here when all the governors have discretionary powers, so when they have to reserve the bill for the consideration of the President of India, so whenever they are reserving the state bill for President, they will have. Then when he has to recommend for the President's rule for Article 356, then when he is given an additional charge of administration of Union Territory, and then when he has to determine the amount payable by the government of Assam, Meghalaya, Tripura, Mizoram to an autonomous district, tribal district council. So here these are the Schedule 6 states, so that is why this is being taken up. Then when he calls upon the chief minister to seek information, so here, so as we used to study earlier, so mark the important keywords so that it will be useful for the revision, quick revision. Then come to next, situational discretion of governors. So here when he has to appoint a chief minister after no party has a clear majority, so during the hung mandate, so he has the situational discretion. Then when he dismisses the council of ministers on an inability to prove the confidence, so whenever the confidence motion is failed, so even then, and then when he dissolves the state legislative assembly, so all are almost the same ones. So whenever there is a confusion between who has to become a chief minister or not, so governor will take one call, and that too whenever he doesn't have a proper majority. Then come to next, principle of subsidiarity and activity mapping. So these are some keywords so which are used during the decentralization, devolution of powers, etc. So what is the meaning of principle of subsidiarity? So it means that here the center is not assuming the centralized role, it is assuming the subsidiarized role. So subsidiarized role means, so it is becoming a subordinate. So that means it is vesting in itself as less power as possible so that the other subsidiaries, so they will have more powers. So principle of subsidiarity means I am becoming subsidiary or I am becoming subordinate to the states. So that is the actual meaning. So here that means the center will look after only defense, external affairs and others, and the remaining important subjects, so they will be shifted to the states. Then activity mapping. So this is one more keyword. So here it means like there are so many activities within a project or a scheme. Say for example MGNREGA, so it has some 300 activities, say like allocation of budget. So after that, so how that money comes and flows through the Panchayat Raj, and who will plan the what assets that has to be created, and who are the people who have to be given the job, or who has to be given the job cards, who will give that job cards. So these are various activities, and these activities have to be mapped for various governments. Say for example some 50 activities are taken up by central government, and these 50 from the state government, and these 50 for the local government. So what the central does, what the state government does, what the local government does, so all these activities will be mapped properly so that there is no confusion, there is neither overlaps in the administration nor the vacuum. So this is activity mapping. So such keywords, they are appearing in prelims again and again, so we make sure that we are thorough with that. Then coming to next, constitutional amendments that require ratification of states. So here some of the ones are the election of President of India and the manner of the said election. So the procedure of election of president, because here the state is also involved. Then extent of the executive power of union. So whenever we are shifting some subjects from the state list to union list or from the vice versa, so we have to take the ratification of the states. Then the extent of executive power of a state. So again the same, the 7th schedule. Then provision related to high courts or union territories. So here also we have to take the ratification. Then provisions related to union judiciary. So all judiciary will come under this ratification category. Then provisions related to high court in the states. So here also again. Then the distribution of legislative powers between the union and the states. Okay, so this we already discussed. Then the 3 lists in the 7th schedule. So but obvious. Then constitutional amendments that require ratification of the states. So here what are those clauses which are linked to the states? So but obvious, they require ratification. So we go with that concept. Then First one, election of President of India and the manner. So here, in the election procedure of President, so states are also involved, that is why. Then, extent of executive power of the Union as detailed in Article 73. So, the variations in the power, reduction or addition of power, so that requires. Then, extent of the executive power of a state. So here, 162. So here also, whenever we are giving more power or taking away some powers, we have to. Then, provisions related to high courts of union territories and the high courts in the state, and also the union judiciary. So for all judiciary, for that matter, we require the ratification of the states. Then, distribution of legislative powers between the union and the state. Say for example, whenever we are amending the 7th schedule, that is the union list, state list and concurrent list, so here also it is required. Then, representation of states in the parliament. So here again, whenever we are changing the 4th schedule, then articles 80, 81 and 82, so we are going to. Then, the procedure of the constitutional amendment itself. So Article 368 itself, so that requires ratification. Then come to next, establishment and abolition of legislative council. So many states, they have proposed to abolish and also to establish legislative councils. So in that perspective, it becomes important. So parliament may by law, so remember this, by law provide for abolition of legislative councils of a state. Then if the legislative assembly of the state passes a resolution to that effect by a majority of the total membership of the assembly and by a majority of not less than 2/3 of membership of that assembly present at voting. So this is very similar to the majority that is required for the constitutional amendment. So that is why, so we will remember likewise. Then, no such laws as aforesaid shall be deemed to be an amendment to this constitution. So however the majority is for the state, we are not considering it for the center. That is why the center, the simple majority will suffice. For the state, this special majority should be there. So remember the differences for majority between center and states. Then come to next, appointment of the judges of High Court. So here the judges of High Court are appointed by the President. Then, but the President shall consult the Chief Justice of India, the Governor of the state and the Chief Justice of that High Court while appointing the judges of High Courts other than the Chief Justice. Then the consultation process. So here consultation means a collegium consisting of CJI and 4 senior most judges. So they will recommend the High Court judges. Then the plan on the other hand is spearheaded by the Chief Justice of the High Court in question in cooperation with 2 senior most colleagues. Then the Governor is advised to convey the proposal to the Union Law Minister after receiving the recommendation from the Chief Minister. So now include the procedure will be like this. That is, the procedure begins from the Chief Justice of the High Court and the 2 senior most colleagues. So they will pick anybody for the judge's post and then they will suggest the name to the Supreme Court Collegium. So the Collegium of the Supreme Court, so they will suggest the name to the President. So here President, so he will also consult the High Court judges, then the Chief Minister and then the Collegium of the Supreme Court and then he decides. Then come to next, the powers of High Courts with respect to Supreme Court. So here Article 133. So the appellate jurisdiction of Supreme Court in appeals from High Courts in regards to the civil matters. So how the appeal should be taken and in what cases. So here an appeal shall lie to the Supreme Court from any judgment, decree or the final order in a civil proceeding of a High Court in the territory of India if the High Court certifies under the Article 134A. So here the High Court should certify. Okay, so when it certifies, only then the Supreme Court will take up the case for appeal. Then that the case involves a substantial question of law. So while certifying, the High Court will certify saying that, so this case, it involves a substantial question of law and that is amenable for the appeal. And then the other cases, so here that in the opinion of High Court, the said question needs to be decided by the Supreme Court. So if the High Court itself opinionates that, so I am not able to decide, let the Supreme Court decide. Then, notwithstanding anything in Article 132, any party appealing to the Supreme Court under Clause 1 may urge as one of the grounds in such appeal that a substantial question of law as to the interpretation of this constitution has been wrongly decided. So if the respondent, so if he feels that High Court has committed some mistake in interpreting the constitution, so then they can go ahead and appeal to the Supreme Court, and in this case the High Court's opinion or the High Court certification is not required. Then notwithstanding anything in this article, no appeal shall, unless the Parliament by law otherwise provides, lie to the Supreme Court from the judgment, decree or final order of one judge of a High Court. So here if a case is decided by the one judge in a High Court, so directly the appeal will not go to the Supreme Court. So here after one judge, so 2 judges, 3 judges bench, so that will take up the case. Only after that, so the appeal goes. Then come to next, the important provisions for the Delhi NCR. So here we have to discuss 3 articles, that is Article 239A, Article 239AA and Article 239AB. Okay, so here Article 239A, so this provides for the establishment of Puducherry, and then Article 239AA, so that will present for the establishment of Delhi, and AB, so this will present that in case of any failure of the constitution, so how center should take over the governance in Delhi and Puducherry. So now we discuss about 239AA. So as per the clause 3A of Article 239AA, the Legislative Assembly of the Capital can make laws with respect to any of the matters enumerated in the state or concurrent list under the Schedule 7, excluding the matters regarding the land police and law and order. So except the land police and law and order, so all others it can deal. So these 3, it will come under the center. Then there shall be a council of ministers headed by Chief Minister of the state, which will aid and advise the Lieutenant Governor on the matters. So here the election will be happening and Chief Minister and Council of Ministers will be formed. Then come to next. Moreover, the proviso to the clause 4 warrants the Lieutenant Governor to refer any matter to the President of India for his or her decision if there is a clash of opinion. So if there is a clash of opinion between the Council of Ministers and the Governor, so that will be presented to the President. Then the Lieutenant Governor as a matter of law is bound by the decision of President given thereon. So once there is a clash and the Governor submits the case to the President, and whatever President opinion is there, so Governor is bound to that. Then recent controversy related to the National Capital Territory of Delhi Amendment Bill. So this was controversial because it gave some overpowering role for the President. That means even in the state subject, so if President decides something, so that will prevail over the Council of Ministers. So this was against the Council of Ministers of Delhi. So that is why it was. So we will update if something happens to this in future. Then the administration of Puducherry. So Puducherry is a union territory which is governed by the Article 239A. So the Article 239A, this gives the Parliament to enact a law. So as per that, the Government of Union Territories Act 1963 has been enacted. So here the same act says that the UT will be administered by the President of India through a Lieutenant Governor. Then the section 44 of the act allows the Lieutenant Governor to act in discretion in the matters of lawmaking even if the Council of Ministers has the task of aiding and advising him. So this was the issue between the overpowering role of Ms. Kiran Bedi and others. So that is why then in case of difference of opinion between the Lieutenant Governor and his ministers on any matter, the administrator is bound to refer it to the President for a decision and act according to the decision given by President. So these we remember. And then however, the administrator can also claim that the matter is urgent and take immediate action as he deems necessary. Then under the section 22 of the same act, so prior sanction of administrator is required for certain legislative proposals. Then these includes the bills or amendments that the Council of Ministers intends to move in the Legislative Assembly, and those bills will deal with the constitution and organization of the courts of Judicial Commissioner, and then the jurisdiction and powers of the courts of Judicial Commissioner with respect to any matters in the state list or the concurrent list. So whenever they are going to appoint a Judicial Commissioner, so they have to take the permission of the administrator. So these are some of the clauses. Then come to next, the NFHS 5, the National Family Health Survey 5. So here is a brief one. Friends, keep the data as minimum as possible. So don't flood your brain with so many datas. So here we have the comparison. So when it comes to the children aged 6 to 59 months who are anemic, so anemic children, so it is like we are improving. So in 2005-6, we had 69.4% of children who are anemic. So now it is 67. And then children under 5 who are stunted. So stunting has also been improved. That is from 48, we have reduced to 35.5%. Then children under 5 who are wasted. So here also from 21 to 19.3 or 19.8 to 19.3. And then the children who are under 5 and who are severely wasted. So this we have increased. So it is like from 7.5%, we are increasing to 7.7%. So here that severely wasted, we will remember. And then children under 5 who are underweight. So here also like we have improved from 35.82, we have reduced to 32.1%. Then children aged 6 to 23 months. they have receiving adequate diet. So are they receiving? Yes, they are receiving. So we have improved here from 9.6 to 11.3%. Then institutional births, so that is also increased, that is from 78.9% to 88.61. So here, if we consider overall from the 2005-2006 statistics, so only the severe wasting, so we have been worsening, and if we consider 2015-16 data, so here in the anemic category also, so we are increasing. So mark this 1 and 2. So you remember only these two because you will not go through the gut feeling and you will hit as improving everywhere. So it is not everywhere. So if you consider 2005-6 data, so we are worsening throughout in the severe wasting, and if you consider 2015-16 data, so in that data this anemia, so that is also worsening. Then come to next, the MGNREGA. So here the government had decided to set up MGNREGA Urban version. So that is why the MGNREGA as a scheme, it becomes important. So here is the press release of that. So here, whenever you go through the press release, also revise the All India Quarterly Establishment Based Employment Survey, AQEES, and also PLFS. So make sure how they are different. So we will also take up the same in the next class also. Then the objectives of MGNREGA, so they provide 100 days of guaranteed wage employment to rural unskilled labor, and then so they are aiming to increase the economic security. So mark this as important. Then decrease the migration of labor from rural to urban areas. So even decreasing migration is also one of the goals. Then the scheme is funded by the central government, which bears the full cost of unskilled laborers and 75% of the cost of materials for work. So full payment by center, and also whenever it comes for the material for building construction, 75%. Then the central and state governments audit the works undertaken under this act. So the auditing is done through the reports sent by the Central Employment Generation Council and the State Employment Generation Council. So these councils are being set up separately to make sure that, so to audit the MGNREGA scheme. Then the Office of Profit. So here the expression Office of Profit has not been defined in the Constitution or in the Representation of People Act. So here only the Article 102 Clause A or Article 191 Clause 1 Subclause A. So here the Constitution of the MPs and MLAs. So only this will give a brief reference on the Office of Profit. So it says that so a person cannot become an MP or an MLA if he holds an Office of Profit. Okay, so here the mechanism for determination of the Office of Profit at the parliamentary level. So who takes it up? Here the Joint Committee on Office of Profit. So Joint Parliamentary Committee on Office of Profit. So it has been constituted consisting of 10 members from Lok Sabha and 5 from Rajya Sabha. So this will take up the task of deciding whether an office is an office of profit or not. And then the committee generally applies two tests, that is the emoluments and the allowances attached to the members and the nature and functions of that body. And here if a member of a body gets only compensatory allowance and the body exercises merely an advisory function, then no disqualification would arise. So mark these two as important then. But if the allowance given are more than compensatory and or the body exercises executive and financial powers and is in a position to wield influence and patronage, then its membership would not exclude from the disqualification. So this is an Office of Profit and this is not. So mark these keywords and then come to next. Interstate Water River Dispute Amendment Bill 2019. So some of the features of these are, first one, the Disputes Resolution Committee. So this will be set up. So central government to set up a Disputes Resolution Committee, and that DRC will get a period of 1 year, and that is extendable by 6 months to submit its report to the central government. So if there is any issue, so within 1 year or 1.5 years, the report has to be submitted. Then permanent tribunal. So all existing tribunals will be dissolved and the pending adjudication will be transferred to its newly formed tribunal. Then composition of the tribunal. So the chairman, then the vice chairman, and not more than 6 nominated members. So that is the judges of Supreme Court or of a High Court nominated by CJI. And then the central government may appoint 2 experts serving in Central Water Engineering Services. So here 2 experts from the Central Water Engineering Services and 6 from Judiciary. So these are some of the ones. And then moving further, the time allotted to the tribunal to take its decision is a period of 2 years, extendable by a maximum of 1 year. Then decision has the same force as that of an order of Supreme Court. And then the decision of tribunal will be final and binding on the parties involved. So they have to bind together. So if they are not binding on the judgment, so then they can be penalized. Then maintenance of data bank and information. So the bill also provides for transparent data collection system at the national level for each river basin. Then come to next, borrowing powers of the state government. The Indian states are not allowed to raise the loans outside India and only have option to raise the loans either from the government of India or through the public loans. So mark this as important. Then it is very difficult and lengthy process for the state to raise a public loan. So they are allowed only the public loans, even that is difficult. Then it needs a prior consent of the government of India. So consent of the government of India is required to avail for public loans. But the consent cannot be issued if a part of a loan advanced to the state by the union government is still pending. So if some state has already taken some loan, so further permission will not be granted. So that means that the center says pay that first and I will give new loans later. Then center is allowed to run up the deficits by borrowing from RBI. So center has this provision, that is it can borrow from RBI, but the states have to adhere to the overall draft limit laid down by the RBI. So some overdraft limit will be there. Above that, they cannot borrow. Then external credits sanctioned for the state projects are entirely allocated to the states. And then external credits sanctioned for a state project are not entirely allocated to the states. So here the external credits will be there. That means, so if the scheme is working well or if the scheme is going short with any funds, so at that point of time some additional funds can be given. So these external credits, so if there are 10, not all the 10 will be allocated to the states, so 5 will be in the control of the center. So here also for the credits and also for in case of emergencies or shortage for any scheme, even there the state doesn't have full autonomy. Then come to next, the inner line permit. So here Ladakh administration issued the notification regarding inner line permit, that is it removed the inner line permit. Then according to notification, requirement of an inner line permit for Indian nationals including the domestic tourists and the local residents has been completely removed. Then the restriction on the stay of foreign tourists has also been relaxed from 7 days to 15 days in tour circuits of bordering areas like Neoma, Nubra and places in Leh and Kargil. So even for foreign tourists, relaxation is being given. Then now what is inner line permit? So this inner line permit is not written in constitution. So this takes its origin from the Bengal East Frontiers Regulation Act, and this ILP is a document required by non-natives to visit or stay in states which are protected by the ILP. So this is like a permit. Then presently 4 northeastern states like Arunachal Pradesh, Manipur, Mizoram and Nagaland are covered under this system. So now every state is removing partly, so we will update which and all state will remove it completely. Then it is issued by the concerned state government and can be availed by applying online or in person. So just like the FASTag, you can also purchase inner line permits. Then come to next, SUPACE. So Supreme Court of India launched the first artificial intelligence driven research portal, that is the Supreme Court portal for assistance in courts efficiency. So the SUPACE, and it is a portal through which Supreme Court intends to leverage the machine learning to deal with the amount of data received in filing the cases. And it is a hybrid system and a perfect blend of human intelligence and machine learning. And the AI driven tool is designed to only process the information and make it available to the judges to take an action, and it will not take any part in decision making. So the artificial intelligence machine, so this will not give the judgment, it will just fetch the necessary information. So mark this as very much important, and only the assistant work it is doing, not the adjudicating work per se. Then come to the last part. Friends, there is lot of difference between the study as a compulsion and study as a passion. So if you are studying as a compulsion, so your brain, it likes to get away from that, as when you sit for studying. So 3 hours, 4 hours, it keeps on counting. But if you are studying with passion, so your brain prompts you to sit in front and study as much as you can, to gain as much knowledge you can. So make sure that you will develop the study or the knowledge gaining process as a passion, as a hobby, and that will fetch you more satisfaction in your life. So do it. All the very best. Good luck, friends.